All rise.
The Kosovo Specialist Chambers is now in session.
Good afternoon, everyone, and welcome. Court officer, could you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good afternoon, Your Honor, and to those joining both in the courtroom and remotely. For the Specialist Prosecutor's Office this afternoon are Alan Teager, Senior Prosecutor, Ward Ferdinandus, Head of Investigations Prosecutions, Marlene Yaya Haga, Legal and Disclosure Officer, and also joining us today are SPO interns Mia Vukovic and Ruth Del Pino. And I am Claire Lawson, Senior Prosecutor.
Thank you, Madam Prosecutor. Now let me turn to the defense. Mr. Kehoe, please.
Yes, good afternoon, Your Honor. Gregory Kehoe on behalf of President Hashim Thaci, along with Pierre Prosper, Dosted Palaska, Sophie Menegal, and down in the third row is Bonnie Johnson. Thank you. Oh, I forgot. And the good-looking fellow up there on the left with the beard is Jonathan Greenblatt.
Thank you, Mr. Kehoe. Let me turn to Mr. Emerson, please.
Good afternoon, Your Honour, and to all of those in the courtroom and beyond. I appear this afternoon on behalf of Mr. Vasili, assisted in the courtroom by Mr. Andrew Strong, counsel, Ms. Annie O'Reilly, counsel, Mr. Quitim Kerveshi, counsel, and Ms. Pascal Longley as a case officer. We're also joined today by counsel specialised in constitutional matters, Haradin Kuchi.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, good afternoon. I appear for Mr. Recep Selimi, and I'm assisted today by Mr. Jeffrey Roberts, Dr. Rudina Yassini, and Ms. Fortuna Sharametti. Thank you.
Thank you, Mr. Young. And Ms. Alagendra, who is in the courtroom.
Finally. Good afternoon, Your Honor. Venkateshwari Alagendra for Mr. Krasniqi, together with Mr. Aidan Ellis, counsel, and Mr. Victor Baisu, counsel, and we have our legal associate, Mr. Mentor Bichiri.
Thank you, Ms. Alagendra. And for the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the counsel for victims. Mr. Laws, please.
Good afternoon, Your Honour, and good afternoon to everybody joining us today. I'm Simon Laws, and I'm counsel for the victims in this case.
Thank you, Mr. Laws. And finally, I turn to the registry. Mr. Nilsson, please.
Good afternoon, Your Honour. Jonas Nilsson, Judicial Service Division, Registry.
Thank you, Mr. Nilsson. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 22 January, I scheduled this 10th Statutes Conference. I asked the parties to provide with written submissions if they so wished. On 1st February 2022, the SPO, 3 defense teams, and the registry submitted their written observations. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, specifically disclosure, translations, SPO investigations, and defense investigations. As usual, I will invite the parties to present their views in a concise fashion about each item. But before we go into matters pertaining to disclosure, I would like to address the Thaci defense request to be heard on matter relating to pre-detention review and to the SPO's submissions on handling confidential information and the parties' contact with witnesses. With respect to detention review, I invite the Thaci defense to make its request in the context of the next detention review. As regard the SPO's submissions concerning the handling of confidential information and the parties' contact with witnesses, I ask the registry for submissions, which were filed yesterday and distributed this morning. I invited the parties to reply to these submissions in writing by 14 February 2022. I would like the parties to present their views now on whether additional oral arguments are necessary or whether they prefer inter partes discussions at this stage, as suggested by some of the defense teams. Then the degree to which such a hearing could be conducted in public, and finally, whether the parties would be available on Tuesday, 22 February, in the afternoon, if such a hearing would be scheduled. I will first ask the defense for their views on this matter, starting with the Thaci defense team, which made the request initially. Mr. Kiu.
Yes, Your Honor, thank you for the floor. We absolutely would like a hearing to discuss this.
I think a microphone is, oh no, sorry.
Is it not on?
No, it's the other one. So, no, sorry, I think that's good. I was only looking at the other one.
Oh, okay. The wires kind of extend a bit. We absolutely would ask the court for a hearing on this matter. We think it's crucial. We think the position suggested by the SPO is an invasion of the defense camp. It's an invasion of the attorney-client privilege, and it is just unsupportable. And that we must discuss this matter because what they have put on the table for Your Honor to consider is completely untenable and will not allow the defense to vigorously defend our clients the way they should be defended, with the SPO sitting across the table with regard to these witnesses. So yes, I will check my schedule on the 22nd, Judge, if I can just do that at the break. But the Thaci team absolutely categorically would request a hearing on that issue. With regard to the pretrial matters, the pretrial detention matters, Judge, I put that on simply because obviously there's an appeal sub judice at this point. However, given that we will probably be back before Your Honor, we were looking for some guidance from Your Honor, some guidance as to what Your Honor wanted. There were submissions made by the Kosovo police that the SPO decided to criticize and cause to be somewhat corrupt, without doing it in public, of course, behind closed doors and confidential issues. And our submission on that issue is yet another hearing on that issue, so Your Honor can ask anybody from the Kosovo police or any third-party country questions about any arrangement for pretrial release. It's impossible to give every piece of information that Your Honor may want. Your Honor asked questions of the Kosovo police. Answers were provided. And Your Honor wrote in its last decision that there were some questions with regard to that information. I understand that the court has questions. The proper methodology I submit to Your Honor is bring those people here. Sit them down on the witness box and ask them questions on the methodology that they will employ, be it the Kosovo police or any third-party country. That's all we're asking for at this point, Judge. And that type of approach is something that I think will be very helpful for the court and will clarify any lingering questions that the court may have. And I would ask the court if we could do that as soon as possible.
Thank you, Mr. Kihu. Mr. Emerson, please, on the proposal to schedule a hearing specifically for the SPO request on handling confidential information.
Yeah, on both of the requests made by Mr. Kehoe, we enthusiastically support the position he's advanced. As regards the second point, as you will recall, I've been making the argument since the first provisional release application that can't rule on that without having heard from the Director of Police. And that was one of the grounds of appeal that resulted in the first decision being turned down. has been a live issue ever since. And each time, I mean, the appeal has all been turned on the fact that you didn't do enough to inquire. And it's the second appeal. But I mean, at the end of the day, you can put that right and show an open judicial mind by hearing the witness whose evidence you have found to be insufficient in some form or another. So we would strongly support both applications for a hearing, and the 22nd of February is entirely convenient.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, likewise, we strongly support the submissions of Mr. Kehoe on behalf of Mr. Thaci. There's no reason why we can't have a hearing in public. This is a discussion. These are submissions on law. In fact, if we have a public hearing, it will be a very straightforward way to narrow the issues quickly and efficiently. And so I applaud Your Honour for considering this course and setting the date. As far as the date's concerned, the 22nd of February is convenient to us. Thank you.
Thank you, Mr. Young. And Ms. Alejandra, please.
Your Honor, we support the position taken by all defense teams for the reasons they have given as well. On the date, Your Honor, could we come back after the break? I'm grateful.
Thank you, Ms. Alejandra. Madam Prosecutor, please.
Thank you, Your Honour. On contact with witnesses and confidential information, submissions have already been made in writing, and there's the opportunity for the parties to now reply further in light of the registry submissions that were notified earlier today. However, should Your Honour consider a hearing necessary, having received those further submissions, we would be available on the 22nd of February. Thank you.
Thank you, Madam Prosecutor. And let me turn to Mr. Laws, please.
Thank you, Your Honour. Your Honour, we are neutral as to whether the further submissions should be made orally or in writing, but we are not neutral about the outcome of those discussions, because this is a matter of great importance to the victims who are also witnesses in this case. And so we're happy to do it either way. The 22nd of February, if it's determined that there's to be an oral hearing, is a date that's convenient to us. Thank you.
Thank you, Mr. Laws. Mr. Nielsen, do you want to take the floor on this?
Thank you, Your Honour. No, nothing to add. We are always available for a hearing.
Thank you, Mr. Nielsen. So I invite the parties to reply to the registry submissions in writing before the 14th of February, and to inform the court management unit about your availabilities on the 22nd, and I will make a decision shortly after the 14th of February to schedule or not a hearing based on your written submissions. Let us now move to the first topic that was listed in the scheduling order, which is disclosure. And as usual, I will give the floor to the parties on the disclosure of each category of material separately. First, the 1021B material, which is the material the SPO intends to use at trial. I also invite the parties to give an update on the witness entities in legal workflow during this round of discussion. Second, the Rule 1023 material, which is the material relevant to the case, as listed by the SPO. Third, the Rule 103 material, which is exculpatory material. And finally, the Rule 107 material, which is protected material for which the consent of the provider is requested. So let us start with the disclosure of the Rule 1021B material. At the status conference on 29 October 2021, I extended the deadline for the disclosure of outstanding Rule 1021B material and the translation of such material to 31st January 2022. During the last status conference, the SPO indicated that disclosure of the English translation of 496 items and the Albanian translation of 545 items remained outstanding. The SPO also mentioned that less than 10 items of Rule 101B were still to be disclosed. In its written submissions, the SPO indicated that since the last status conference, it disclosed 3 Rule 101B disclosure packages containing new material, and 3 packages containing translations of previously disclosed Rule 102.1b materials. I note that the number of items disclosed is substantially higher than what was expected. The SPO considers that it has now completed disclosure of existing Rule 102.1b materials, including translations, subject to any future ruling on the last SPO request on protective measures, and with the exception of the audiovisual recording of and 2 associated exhibits addressed in the extension decision I issued on Monday. The SPO also indicated that it intends to make related disclosure pursuant to Rule 102.2 in relation to the evidence of 2 witnesses and will do so as soon as the relevant transcripts are available. In its submissions, the Thaci defense requests that the SPO confirm whether disclosure pursuant to Rule 102.1b has now been completed, in particular, English translations of all documents disclosed as incriminating by the SPO, and all items mentioned in witness statements and interviews. I invite the SPO to respond to the defense interrogations, to present their submissions on the discrepancy between the amount of material disclosed and their previous estimates during the last status conference, and to provide a best estimate for obtaining the relevant transcript for the Rule 102.2 witnesses and making an application on this matter. Finally, I would also like the parties to give an update on their inter partes discussions on the witness entities that have been created in legal workflow. On this topic, I note that certain additional metadata, including modes of testimony and linking other relevant filings as the case progresses, will be added by the registry. However, I note that the persistent concern of the defense on this tool and their demand to populate the witness entities with additional information, such as the witness's name, date of birth, and protective measures. I invite the parties to present their submissions on these issues, in particular for the SPO to explain their concerns with respect to populating these witness entities. Madam Prosecutor.
Thank you, Your Honour. As the Court is aware, there are a very small number of items held by third parties for which an extension has been granted. As you mentioned, that is 2 associated exhibits and accompanying recordings for certain already disclosed transcripts. Otherwise, the SPO has completed disclosure of existing Rule 102.1b materials, including translations, and that was by way of disclosure packages 154 to 159. I'm pleased to also be able to provide the Court with an update in relation to the outstanding items. Yesterday, we received official confirmation that the third-party entity in question that has the recordings is now in a position to release those recordings to us. Similarly, yesterday we were also informed that one of the 2 associated exhibits has been cleared. So we expect to receive each of those items shortly and will proceed to disclose them once received. That means there's now only 1 item left to be resolved. As Your Honour mentioned, there are a couple of other matters that we mentioned in our there was one other matter that we mentioned in our written submissions for the awareness of the Court. That was the Rule 102.2 disclosure and related filing that we intend to make. My understanding is that we are only awaiting the Albanian translation of one of those interviews now, so we would expect that to be ready in the near future, and as soon as it is, we'll be able to make the application. The near future in this context hopefully means next week that we would receive it.
You anticipated my question.
Yes, Your Honour. And there is one other matter that I would mention for the awareness of the Court and the parties, and that is obviously that trial proceedings are ongoing before Trial Panel 1. and that is continuing to generate certain materials that fall within our disclosure obligations. The prosecution case in that trial was closed earlier today, and so where necessary, we'll be sure to continue to fulfill any disclosure obligations in this case arising out of those proceedings. With regard to witness entities, the SPO released all of the witness entities in December 2021, and those witness entities have prior statements and associated exhibits linked to them. The registry has also confirmed that during inter partes discussions that, consistent with practice in other cases and before other courts, as proceedings progress, it will update certain additional metadata and link relevant filings. The SPO does not actually have the technical capability to upload further metadata to the witness entities in legal workflow. However, as indicated in our written submissions, we are happy to arrange to provide the registry with witness names and filing numbers of relevant protective measures decisions to assist them in adding such information. And this was indicated in inter partes communications that the registry would be in a position to do so once we provide them with that information. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Thank you, Your Honor. Several items, of course, consistent with Your Honor's question about why there was a estimate made of 1021B disclosures that were going to be made, and it was significantly higher than that. We have received, since the last conference, Rule 1021B matters 1,954. On Monday, this past Monday, 31st of January, we received, of the 1,954, we received 1,613. So as far as this being a rolling production of 1021B material consistent with the OTP's practice, this document production dump is given to us on the eve of a conference before Your Honor. That being said, counsel has said that they have fulfilled their 1021B requirements. Of course, going to the trial that's before trial panel 1, the Salih Mustafa matter, I do believe that there was a decision by that chamber essentially bringing it back to this chamber with regard to those disclosures. We're talking about transcripts and exhibits. We have received none of that. That trial has been going on for some period of time. So when they say that they've completed their 1021B disclosures, that's just simply not accurate because we have not received that. With regard to the rest of the 1021B, there was another item that was filed by the prosecutor on Monday talking about redacting documents. And the prosecution now seeks to add 132 documents, statements, and exhibits that they maintain that they overlooked. And they're looking for protective measures in that regard, too. They have redacted these documents unilaterally, not asking the court. They just have redacted the documents, which is, frankly, the MO for the prosecutor's office. Obviously, in terms of the pretrial brief, which we all know that the prosecutor was scheduled to file that brief per Your Honor's order on the 17th of December. Did the defense receive that document on the 17th of December? No. We did not receive that document until the 21st of December, some 4 days later. There was no request of this court to delay disclosure of that pretrial brief to the defense. The prosecutor, consistent with their conduct, just did it on their own. Didn't pay any attention to Your Honor's order and just did it. They filed the brief on the 17th. They filed it under seal, and we didn't get it, the redacted copy, until the 21st, in complete violation to Your Honor's order. But be that as it may, they now come here, the exhibit list deadline, again, Your Honor ordered that exhibit list deadline to be the 17th of December, if my memory serves me correctly. And now they're adding another 132 documents, statements, and exhibits well after the period of time that they were ordered to disclose it. Unilaterally redact these documents, but they want to now add it all to the witness list as 1021B exhibits. Deadlines don't seem to mean anything to the SPO. They don't, your court's orders mean little to what they are going to do and how they're going to disclose matters. At least, they could have asked the court, and I assume they knew this was the case prior to the 31st of January, whether they could redact these documents. But they didn't, and they just did it on their own. And now we have these 132 more exhibits floating in the ether someplace that are redacted consistent with how the SPO redacts everything. With regard to the actual legal workflow, Your Honor, I am going to bow to the Krasniqi team to answer Your Honor's questions in that regard because, frankly, they're smarter and better schooled on this issue than I am. And at the risk of misleading you with something I'm not completely educated on, if I can turn to the Krasniqi defense on that score at the appropriate time now or wherever to address that matter. I do believe I've addressed all of Your Honor's points.
Thank you, Mr. Kihu. Mr. Emerson, please.
I'm going to ask Annie O'Reilly to present the Sealy submissions on disclosure, please.
Thank you, Mr. Emerson. Ms. O'Reilly, please.
Thank you, Your Honour. We adopted submissions made by the Thaci defence and would just like to add while we're here, there's no great place to put this, the request that the prosecution made, the 1021B request on Monday. Paragraph 3 states that those further materials were either obtained between late 2021 and January 2022 or simply overlooked. So I just want to make clear with respect to those materials that are coming into their possession all the time, we need assurances that those are also being reviewed for disclosure under other rules such as 103 and 1023. We haven't had any update to the 1023 list since it was disclosed last summer, and that seems slightly incredible. So we just want to make sure that that process is ongoing, that they are continuing to identify materials that are disclosable under other rules. Other than that, no further submissions from us. With regards to the legal workflow, yes, we've started the inter-parties forum. There's not much to add on that. It's not a very useful system. We're trying to see if there's scope for improvement. So far, not much to report. Thank you.
Thank you, Mr. Ray. Mr. Kiu,
Your Honor, did you want our commentary on the 1023 issues now or? Okay, thank you.
Later. Mr. Young, please.
Yes, Your Honour, briefly, we do also support the submissions in relation to the Thaci defence on this issue. There's one additional point I'd like to raise. The prosecutor has just addressed you this morning, or this afternoon, and has quite probably accepted that the prosecution hold 1021B disclosure obligations in relation to the materials in the previous trial proceedings in this court. The only matter I raise now for Your Honour, given the situation, the deadline timelines, is that this material should be disclosed very quickly. So I ask Your Honour to set a deadline for the prosecution to disclose these materials to the defence, because as Your Honour will appreciate, the 1021B material in the previous KSC proceedings are effectively akin to witnesses' prior testimony. So we should have that as soon as. And so I ask Your Honour to set a date. Thank you.
Thank you, Mr. Young. Ms. Alagendra, please.
Could Mr. Ellis address the issues on disclosure, Your Honour?
Sure.
Thank you.
Thank you, Mr. Alagendra. Mr. Ellis, please.
Thank you, Your Honour. We support the submissions that previous defence teams have made on these issues. In relation to the working forum, it's right that, as Ms. O'Reilly said, the first meeting has happened. It didn't solve all of the issues. but the next meeting has been scheduled, and we will try to progress the inter partes process a little further before we bring matters back to Your Honour.
Thank you, Mr. Ellis. Let me turn to the registry. I guess you've attended the legal workflow meeting. Do you see room for improvement, especially following what Madam Prosecutor said about the fact that you could populate the witness entities according to what Ms. Lawson indicated?
Thank you, Your Honour. Yes, with regard to, it's correct, you have summarized the position well, and Ms. Lawson as well. As for the witness entities, there is certain metadata that will be provided and will be dealt with by the registry. I'll add maybe as a clarification that this metadata includes protective measures, which registry also will be in a position to add to it. So that's as far as it can go. And this will be, well, besides the protective measures, where there is certain information available, of course, already now, much of this will be as the case progresses and witnesses will testify and so on. Thank you.
Thank you, Mr. Nielsen. Let me turn to the prosecution. Madam Prosecutor, if you could respond to the defense question, notably the redacted exhibit, the basically unilateral redactions, then the question about the new documents that have been disclosed, have they been reviewed for notably Rule 103, i.e. to determine if they are exculpatory, and also for the proposal to set deadline to disclose materials that was raised by Mr. Young, and any other matter you would like to respond to also. Thank you.
Thank you, and I in fact neglected to respond to your initial question on the discrepancy in numbers, and I will do so now. At the time of the last status conference, what we were aware of was one associated exhibit and the lesser redacted or unredacted materials disclosed in packages 154, which had 2 items, and 155, which had 7 items. As indicated in our written filing on Monday, that's filing 670, the additional 60 items plus translations, the 132 includes translations, we identified as not having been included in prior disclosure packages during the additional verifications we conducted while finalizing the Rule 95.4 materials and preparing the Rule 109C chart. And these have since been promptly disclosed on the 31st of January deadline. It is correct that we disclosed some of those items with redactions provisionally in place, while we simultaneously made an application to the court on Monday. And we did that in order to provide them to the defense teams at the earliest possible opportunity. With respect to the figure of 1954 items quoted by the Thaci defense, that obviously includes translations of previously disclosed materials. And in some cases, there are multiple translations associated with a single original item, which in part explains the discrepancy in numbers. But that number quoted is also slightly misleading in this context because it includes the 341 items included in Disclosure Package 137. And that disclosure package was the materials resulting from lifting of delayed disclosure protections for certain witnesses, which fell at the same time as our filing of the pretrial brief and related materials. In relation to the new documents which are being received in the office, those are indeed being reviewed for disclosure under other rules. We'll come to it, I'm sure, in the context of Rule 103 and other matters, but those are in fact the documents that we're currently focusing our Rule 103 review on, that is materials received in the past approximately 7 months in the office. And in relation to materials from Trial Panel 1, certain materials from that case have in fact already been disclosed to the defence in this case. And as I mentioned, the prosecution case closed earlier today, so we will be now promptly reviewing all the materials generated by those proceedings, preparing them for disclosure in a timely manner. I don't immediately have the volume and wouldn't be able to give an estimate, but we will do it promptly. Finally, in relation to the pre-trial brief, it was filed on Friday the 17th of December in accordance with the deadline given, and it was notified on Monday the 20th of December in accordance with normal practice, being the next business day. And then the confidential redacted version was notified to the defence teams the very following day after that. It was obviously a very voluminous filing with 3 large annexes which required careful redaction. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor, obviously the prosecutor misses my point. The point is, with regard to the brief, that if they're going to decide not to file it with the parties in a timely manner, they should ask permission of Your Honor to do so. They didn't. They just decided to do what they wanted to do, when they wanted to do it, and how they wanted to do it. They didn't. What is the point of having a court order when Your Honor orders for that document to be filed with Your Honor's complete understanding that it's going to be given to the defense, and it's not? Without asking Your Honor for permission to give it 4 days later. It's not. They just do what they want to do. And why wasn't it given to us on Monday if they decided to do it on the 17th evening? They didn't do that either. There's just a pattern here of the prosecutor doing what they want to do. And then it just goes back to what we were talking about before. Their addition of these 132 documents that they used to unilaterally redact. They didn't have the foresight, and this is a rhetorical question. They didn't have the foresight to ask Your Honor's permission to do that prior to the 31st of January? That we have additional redactions that we want to turn over by the 31st of January? Is it okay with the court if we redact that? No, they didn't do that. Oh, keep in mind that the date that Your Honor ordered that the exhibit list would be cut off was December 17th. With regard to the Salah defense, the reason why we asked for the Salah Mustafa defense, that's the case in front of case 05, was because it's the same crime base, or one of the crime bases alleged here. And there are some items that have been given. But with regard to everything that happened during the course of that trial, all of those witnesses and those exhibits, we have not received those. Let us be clear. We have not. And that's all I have on this matter. Thank you.
Thank you, Mr. Kihu. Ms. O'Reilly.
No further submissions from us, Your Honour.
Thank you, Ms. O'Reilly. Mr. Young?
No, thank you.
Mr. Ellis?
No, thank you, Your Honour.
Thank you. Just for the record, I think the SPO pretrial brief was filed on Friday 17th evening, and the confidential redacted version was filed on Tuesday the 21st. So it is true that it is 4 days later, but it's in practice probably 1 or 2 working days, correct?
This is true, Judge, but it is emblematic of a larger pattern and problem. If they had come to Your Honor with permission to do that, we would be having a different conversation. But that didn't happen. The court wasn't given the respect of allowing the SPO to delay the redacted disclosure until the 21st.
Thank you, Mr. Kihu. I think in future decisions, I will explicitly mention that the confidential version shall be filed the same day as the strictly confidential version. Let us now move to the Rule 103 notice and evidentiary material. I remind the parties that at the Statutes Conference on 29 October 2021, I suspended the remaining defense deadlines for Rule 1023 material. Since the last Statutes Conference, the SPO indicated that 14 Rule 1023 disclosure packages have been released, containing more than 14,300 items. The SPO also indicated that the pending requests are not being processed in a strictly chronological order, but rather in, and I quote, the most efficient way for the SPO. It is currently preparing a number of requests for protective measures in respect of certain items identified so far, and it has begun to engage with relevant defense teams regarding the materiality of a limited number of other requested items. Regarding the disclosure timelines of Rule 1023 material, the SPO considers that where the proposed deadline of 4 March 2022 to be imposed for the defense to complete all requests for items from the Rule 1023 notice, there is a significant risk that an unnecessary burden would be placed on all the parties. The defense also submit that no deadline should be re-established for requesting such material. The defense indicates that some items might become relevant in ways which could not reasonably be anticipated at this stage. They should therefore not be prevented from making subsequent Rule 1023 requests when the need arises. The defense also considers that it shall have the ability to conduct further review of the Rule 1023 notice and make further requests each time new information is received. However, some defense teams have also indicated that they could be in a position to propose a deadline for Rule 1023 disclosure at the next Statutes Conference. Finally, I also note that the Krasniki defense supports the reintroduction of practical deadlines for the SPO to respond to Rule 1023 requests, and it notably requests that deadline should also be imposed on the responses to Rule 1023 requests, which have already been made. The Krasniki defense also requests the SPO to provide the defense with a copy of a master Rule 1023 spreadsheet with each disclosure batch in order that all parties can keep track of which items have been disclosed and which remain outstanding. I would like the parties also to explain what were the result of their inter partes discussions on this matter, and more generally on the disclosure calendar of this category of material. Madam Prosecutor.
Thank you, Your Honour. In relation to Rule 1023 disclosure, as you mentioned, since the last status conference, and at the time of our written submissions, we had disclosed 14 further packages containing in excess of 14,300 items. And as we have done consistently over the past 3 weeks, there were further packages disclosed today which contain over 3,000 additional items. As explained in our written submissions, the pending requests are not being processed in a strictly chronological order. And that is so that, for a number of reasons. Firstly, so that each of the defence teams receive a portion of material on a regular basis. Secondly, so that material which we can more easily or quickly process and provide to the defence is made available as soon as we can. And thirdly, it assists us in the redaction process to have material of a similar nature or coming from the same case files reviewed together in order to ensure consistency in protective measures. For example, it is the case that certain earlier requests for the Krasniki defence are not yet completed, but we've already addressed almost 80% of the request that was received on the 13th of January. And similarly, we received a 10th Vaseli request for slightly over 3,200 items 3 days ago on the 1st of February, and today we already disclosed approximately 90% of those requested items in Disclosure Package 163. So what we're aiming to do is provide the materials as soon as we possibly can, even if it's not strictly in the order in which the requests were received. While we do not concede the materiality of many of the items requested, we've chosen to challenge materiality as little as possible, and this is both in order to provide the defence with maximum disclosure and to minimise litigation. So as indicated in our written submissions, we are engaging in discussion of the materiality of certain items. It's a relatively small number with defence teams, and we do anticipate making protective measures requests for certain other materials. As Your Honour summarised with respect to the proposed schedule of deadlines for Rule 1023 requests and disclosures, we are concerned that such a timeline we are concerned about such a timeline being imposed from two perspectives. The first is that we believe it would result in large further requests for materials that might not otherwise be sought at all. Due to the broad nature of the relevance criterion, there are many items on the Rule 1023 notice that are of only tangential relevance at best to the case. However, imposing a deadline may lead the defence teams to request almost all items on the notice if they believe they would otherwise be precluded from doing so. And this would result in an excessive burden on all parties. And relatedly, from the SPO's perspective, we're continuing to balance a lot of competing priorities. And new requests and deadlines imposed in respect of Rule 1023 materials would certainly compromise other ongoing reviews, including our efforts to complete review of exculpatory material. This is something we'll be coming to shortly on the agenda, and certainly that review should take priority to processing the, if you like, more residual items on the Rule 1023 notice. So, as mentioned in our written submissions, we would request that these type of deadlines for requests or for processing not be put in place at this time. And we would certainly request that materiality and protective measures reviews not be bifurcated if a timeline were to be imposed, as this would definitely result in inefficiencies in the review process. I believe there was one other aspect under this that you wish me to address.
I think there was the question of the Krasniqi defense of providing the defense team with a master Rule 1023 spreadsheet in order for them to understand what was already disclosed and what was missing, because the disclosure packages that you file do not correspond to each request.
Yes, thank you. So we do already provide a spreadsheet after disclosure for a particular request has been completed. And this spreadsheet includes information on any items which have not been disclosed. For example, if the request was withdrawn after discussions on materiality, if we have put in a protective measures request for the item, or if it's a duplicate. And as requested items are being disclosed in batches of disclosure packages, going forward, we will also include information in that spreadsheet as to which disclosure batch the item was in once the request has been completed. One of the defence teams had requested us to add item numbers from the Rule 1023 notice to the spreadsheet, and we confirm that we will also be able to do that going forward. However, we're not in a position to provide these type of spreadsheets with each individual disclosure package being released, because many of the documents and batches are being worked on in parallel, and the spreadsheets are not automatically generated. They do take time to prepare. But what I would note is that, save in the case of disclosures following protective measures decisions, like the one which we disclosed to the Thaci defence earlier today, we don't mix documents from different requests in the same disclosure package. So each Rule 1023 disclosure package we release relates to a single request. And we do already send the defence teams emails indicating which request disclosure package relates to. So tracking what has been received on an interim basis is something that the defence teams are already in a position to do themselves. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor, I will get in, talk about the substance of 1023 items as we move forward, but I heard with interest the prosecutor's comment that they made their disclosures to us today along with others in our package, and I certainly would like to share those disclosures with you, document by document, and you can see what's from there, because here is disclosure number 1. Page 2 of disclosure number 1, page 3, page 4, page 5, page 6, page 7, page 8. That's disclosure number 1 for our 1023 request. Is the next disclosure. That's only 2 pages, but equally efficient use of black ink, and let the record reflect that is nothing on any of these documents. The third disclosure, that's only 1 page. That's completely blank. Our next document, the same. This is only 2. So when we make 1023 disclosures, and we have tried to make 1023 requests in a limited fashion, unfortunately, this is what we're getting back. This is the, when counsel talked about their disclosures today, that she said they made 103 disclosures today, this is what they disclosed to us. With regard to the 103 matter, we have several requests that we still have that have been made and remain unanswered, and there will be further requests under 1023, not only in addition to the information that just came in last Monday, the 1900, whatever it is, documents, 1961, but also the rolling information that needs to come with regard to items that are in the pretrial brief and in the indictment. And I raise a question to Your Honor. There, in paragraph 112 of the breach, they charge my client and Mr. Vasily with improper conduct concerning activities that took place in June of 1998. The rest of the information, redacted. Where it was, when it was, who it was, everything is redacted. How are we supposed to put together a 1023 request? And that's just one example, I should say. There are hundreds of them throughout the document, and heaven knows how many there are throughout the indictment. How can we cogently make a request in defense of our clients with that type of information still redacted? I have no idea what to ask with regard to that, Judge, other than to say, what happened in June of 1998 that you redacted? And what I'm probably going to get back is this. Black blank pages. There are still 106 anonymous witnesses, which at some point I submit to Your Honor that we'll maybe know about, maybe prior to trial, maybe 30 days or some weeks before the witness testifies. All of that information, once we find out who that person is, will generate 1023 material. So we have this ongoing lacunae of what we should have and what we do have. And we're still getting information as it comes along, as counsel just reflected, not only last Monday, but the submissions they have, the additional documents that they want to put on their exhibit list. So any deadline at this point, Your Honor, is completely premature. We have no idea exactly what we're answering for on behalf of my client in many different instances without having facts. So with regard to holding the date in abeyance, this is probably the one thing that we agree with the SPO, that date, it's good to find agreement someplace, Judge. That we should hold that date in abeyance because we simply cannot meet a timetable that would say March 4th or wherever it happened to be. Thank you.
Thank you, Mr. Kehoe. Mr. Emerson or Ms. O'Reilly?
Yes, it would be for Ms. O'Reilly to add anything she wishes.
Thank you, Mr. Emerson. Ms. O'Reilly?
Thank you, Your Honour. So, as regards to statistics, we have now requested 19,487, and as of a couple of hours ago, we now have 8,428 of those Row 102 3 documents. Our primary position, lest it be unclear from our submissions, is that no deadline should be imposed. However, if you are minded to force a deadline, as it were, we'll address that at the next status conference. But Ms. Lawson is absolutely right that if you impose a deadline on us, then we will request pretty much everything, because it's the only way that we'll be able to cope under that short amount of time. I just wanted to add that we have so far not received any of the spreadsheets that Ms. Lawson mentioned. That may be because they have not so far completed any of our requests. So I would like clarification on that. Also, even if there is a deadline imposed, what we were trying to clarify in our submission is that it won't be a hard deadline, because there will be changes as to what is material based on what we know about the case. So we will still need to make some requests after the deadline passes. But moreover, that works in both directions insofar as the SPO will also have to continue to add documents to the Rule 1023 list, which is a point I was trying to make earlier, when they come into receipt of material that they is not exculpatory and they don't intend to rely on, that falls into this, broad unused material category. So in that sense, that's another complication that means it's not really possible to set a hard deadline on this anyway. So those are our submissions as regards to that aspect of 1023. Thank you, Your Honour.
Thank you, Mr. O'Reilly. Mr. Young, please.
Yes, Your Honour, briefly, we do support the submissions made by the Thaci defence. To give you an idea of the scale of the 1023 situation, as far as we're concerned, on behalf of Mr. Recep Salimi, we have requested around 52,000 items. We have received around 9,000 items disclosed so far under 1023. And given what my learned friend from the prosecution said, that to date they've not been challenging or been challenging materiality as little as possible, if that's the case going forwards, then the reality, Your Honour, is that we're looking at receiving possibly up to 43,000 new sets of materials. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, in my submission, the most basic information that we need in order to manage this process is to know an idea of how long it's going to take the prosecution to process requests that have already been made. And I understood from the transcript of the last status conference that the prosecution hoped to be able to more concretely forecast those matters for Your Honour today. We've set out in our written submissions the history of the requests that we've made and the responses that we have received. Let me just dwell a moment on the second request made by the Krasniqi defence. That was made on the 7th of October. It related to some 5,945 documents. We've received responses split, I think, across 5 different disclosure batches to date. As at the last status conference, the indication on transcript page 794 was that the prosecution expected to disclose the remainder of that material in January. And then on the 29th of January, we received an email telling us that the prosecution hopes to correspond with us about the materiality of around less than 100 of the remaining documents within the next couple of weeks. So what we have here is a request made now almost 4 months ago, still unanswered, and still with the pending possibility of correspondence about materiality or redactions to come. That's only one request. It was our second request. In terms of the total volume of documents requested, it's one of the more modest ones, at just under 6,000 documents. But there is here, in my submission, a very real concern that if there are no deadlines on this process, then the process is going to continue for some considerable period of time, with all the implications that that has for defence investigations and for the future management of the case. So we fully support what other defence teams have said about the impracticality of setting a deadline for defence requests, but we do invite some supervision of how long it is taking the prosecution to respond to the requests that are made. And we put it in the written submissions to suggest practical deadlines be imposed. We're not standing here insisting on a response within 3 weeks, but we do say some sort of deadline would focus minds, and maybe we would begin getting through the end of this mountain of Rule 1023 disclosure.
Thank you, Mr. Ellis. Madam Prosecutor, are you able to give some information about the timeline for processing the defense requests, as indicated by Mr. Ellis? I'm not asking you a specific date, of course, given the amount of material, but in the ballpark, how long are we looking at? You have the floor. Thank you.
Yes, Your Honour. Minds are very focused in the SPO, and we are reviewing and processing the materials intensively. Currently, we're getting through approximately 5,000 items a week on average. So I can't give an overall estimate. We've obviously received requests as recently as this week, and we've turned them around this week. So we really are providing the materials as fast as we can provide them, and doing so in a manner that we consider to be as efficient as possible in order to get the requests addressed. I think that's all I can say on that. In relation to the Vasselli defence query on spreadsheets, we will revert to you inter partes on that after this hearing. And in relation to protective measures, as both the Chamber and the defence teams are aware, we've been making protective measures requests for as few documents as possible from the Rule 1023 notice. The documents disclosed today were the result of a request for redactions necessary to give effect to existing protective measures. There is no lacuna between what the defence team should be receiving and what they have. We've been disclosing exactly what they should have in accordance with the delayed disclosure timetable in place. Thank you.
Thank you, Madam Prosecutor. 5,000 documents a week. I think everybody can do the math. If we have, let's say, 30,000 documents pending, it's approximately 6 weeks. So this is where we should be at the next status conference. Or am I too optimistic, Madam Prosecutor?
I think that might be slightly optimistic, Your Honour, because there are a significant degree of checks that need to be done on each package and review before it can go out. So while we're getting through 5,000 in terms of review, there is further processing before they can immediately appear. Thank you.
Thank you, Madam Prosecutor. And on the request from the Krasniki defense team to reinstate specific deadlines for their request to be processed, do you have any submissions on this? Mr. Prosecutor.
Your Honor, if you find it necessary to impose a deadline for this specific Krasniki request, we suggest it will be that we finish that request before the next status conference, but that is what the SPO will do regardless of a deadline. Thank you.
Thank you, Mr. Prosecutor. I don't see any defense team requesting the floor. So I take note that it is premature to reinstate any deadline for the Rule 1023 material. That said, I invite the parties to continue the discussion inter partes, both for the processing of the material that is the scope of the existing requests and for the future requests that the defense are going to send to the Specialist Prosecutor's Office. I will not set a deadline to the SPO for the processing of their request at this status conference, but I invite the SPO to process the existing requests, and especially the one that have been filed in October, as fast as possible. And as Mr. Prosecutor, you indicated that these requests are processed before the next status conference. Let us now move to the Rule 103 material. Since the last status conference, the SPO disclosed 2 further packages of potentially exculpatory items. The SPO has...
I apologize,
Mr.
Your
Prosecutor.
Honor. I had to find the passage in the transcript. I would like to point out that I talked about the specific Krasniqi request, and that I believe in October the request for more than 40,000 items has also been filed, which is in a category of its own due to its size. But obviously we will be processing these requests and finish what we can as soon as possible.
Thank you, Mr. Prosecutor. This is noted. Let me continue about the exculpatory material. So the SPO indicated in its written submission that no protective measures request for this category of material is imminent. However, the SPO did not give an estimate on the time needed to finalize its review of exculpatory evidence. In its submissions, the Thaci defense requests that the SPO confirm first, whether and what amount of exculpatory evidence remains in its custody, control, or actual knowledge, and when disclosure of such material currently in its possession will be completed. The Vesely defense also requests, first, that the SPO provide its best estimate of amount of Rule 103 material currently in its possession, and second, to provide a date representing the SPO's best estimate as to when it will complete disclosure of all Rule 103 material currently in its possession. I would like the SPO to answer these defense questions. I stress that exculpatory material must be disclosed according to the wording of the rules, which is as soon as it is in the SPO's custody, control, or actual knowledge. Such evidence is absolutely crucial for the defense investigation and thus for the expeditiousness of the case. Madam Prosecutor, you have the floor.
Thank you, Your Honour. As you noted, since the last status conference, we have disclosed 2 further packages of potentially exculpatory material. That's packages 152 and 160. And as outlined in our written submissions, we're working to complete exculpatory reviews of material held. Review is currently focused in particular on materials that were either received by the office or otherwise cleared for disclosure purposes within approximately the past 6 or 7 months. And in addition, in light of the finalization of the witness list in December 2021, we are organizing certain additional focused exculpatory reviews and searches related to that. Materials in respect of the progress, the current status, we are now over 50% through review of the more recently received or cleared items. So it would be hard to give an estimate, but the review is continuing at a rapid pace for those items. And the results of the reviews that have been conducted have either been disclosed. We've disclosed 21 packages to date of Rule 103 materials, or they're being processed for disclosure, including conducting redaction reviews, or they're being collated for a protective measures request. And we're aiming to collate those materials as much as possible in the interests of judicial efficiency overall. The one other item I would mention in relation to Rule 103 is that in preparation for this status conference, we recalled that in recent hearings, the Thaci defence had expressed interest in receiving materials of a particular individual. And given that quite a number of the materials currently under review relate to international witnesses, we did contact the defence yesterday to ask whether they would like us to prioritise review of any particular item. The response we received was that they would be raising the matter in the status conference today, but I currently have no further information in relation to that. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Thank you, Your Honor. This is, of course, an issue that I have addressed with Your Honor several times over the past conferences. But let me raise a larger issue with Your Honor that will dovetail with this. And it goes to Rule 62. And Rule 62 talks about the duties of the specialist prosecutor. And the rule says, in performing his or her functions, the specialist prosecutor shall contribute to the establishment of the truth of the specialist chambers. The truth of the specialist chambers. Well, Your Honor, were you ever informed by the Office of the Prosecutor during your confirmation hearing, during hearings during the submissions concerning the defense's motion for pretrial release, were you ever informed, Your Honor, that a senior OSC diplomat had advised the prosecutor 4 years ago, 4 years ago, that the criminal activities post-June 1999, the criminal activities charged in this case, the criminal activities post-June 1999 were committed by individuals who sought a chance to gain personal benefit and was not part of an organized campaign from the Albanian leadership. 4 years ago, and we will go through the rest of this. The individual who gave this information was Ambassador Dan Everts, D-A-A-N Everts, E-V-E-R-T-S. And who is Dan Everts? Been a Dutch diplomat since the early 80s in the Ministry of Foreign Affairs here in The Hague and elsewhere. He was posted as head of ECMM in Zagreb shortly after the end of the war in the former Yugoslavia. And then he was posted as the head of OSCE in Tirana shortly thereafter. And in July 1999, Ambassador Everts took over the OSCE mission in Pristina for the entire country, for the implement of the peace plan and to bring the police up to gear and to work with UNMIK and with ULEX to bring about peace and stability in the country. And what did he tell the OTP, the SPO 4 years ago? Well, I just reiterated that Everts' view was that the violence post-1999 was not part of an organized campaign from the Albanian leadership. What else did he tell them? If I may. Excuse me, Judge. In my view, it would be incorrect to call it systematic, organized harassment and to infer that it was directed from above. Rather, I view the situation as one of impunity and permissiveness, where people to pursue ulterior goals, whether ethnic revenge, political control, or material gain. With regard to my particular client, would Your Honor not wanted to have known what this ambassador had to say with regard to my client, Mr. Thaci, who interfaced with Ambassador Everts throughout this time period? And wouldn't you wanted to know this when you were reviewing and weighing the application by the prosecutor for pretrial release? Put aside reasonable doubt and guilt or innocence. Talking about Mr. Thaci, I cannot see any reason or motive why Thaci would have wanted the KLA to commit ethnic violence, as it would have damaged his international standing. In my view, there was a disconnect between the crimes and the central Kosovo Albanian leadership. None of this was turned over to us when we were going back and forth and discussing this evidence. None of this was given to Your Honor. None. And they've had this information for 4 years. While these 4 gentlemen sit in jail since November of 2020, they sat on information that they turned over February 1st, and we'll get to the reason why they turned it over then. One would ask, Ambassador Everts, so why did this happen? Why did this take place? Well, he had an answer for that as well. In my view, the main problems were the absence of the media and enforcement mechanisms, such as the police. He's talking about the violence on the ground after July of 1999, and he says the reason why this went on was the major problem was there was no police. And who was responsible for setting up the police? The UN, OSCE, UNMIC, not the 4 gentlemen that sit before Your Honor, not the Kosovo leadership. This was a Chapter 7 situation under the UN Charter where they had no power to run a police force. It was the internationals running the police force. And how about my client individually? Was he the person that was in charge of this? Would you not want to know this when talking about the Rambouillet conference? Thaci's total lack of control is why the KLA had people like Drine, Reme, and Rambush in leadership roles. So, he's saying he had total lack of control. He had no motive whatsoever to have violence on the ground. That he saw no proof that there was a vertical ordering coming from on top to the violence on the ground. And again, that he had no motive to do so because he didn't have the power to control this, the other KLA members, especially in the outlying areas. Let's continue. That's not the only item he mentions in that regard.
I think I get your point. I think what is important for us today is the procedural point you want to make, that this is Rule 103 material and should have been disclosed earlier.
Well, Judge, I think one last item that Your Honor should take into consideration, not that it should be disclosed earlier, that these men should be released. That you have before you reasonable doubt in this document, and as a consequence of that, Your Honor, these 4 men should be released based on a document that they sat on for 4 years. I go back to Rule 62. This is supposed to be a tribunal that seeks the truth. And the specialist prosecutor is supposed to be seeking the truth. Yet Your Honor never had this document. And we never had it until Tuesday. And we got it, and I will get into how we got it, and Tuesday, as a result of Ambassador Everts' efforts and putting pressure on the Office of the Prosecutor to try to get their document, which they refused to turn over to him. But quite disturbing, and by the way, we're going to get into it. This isn't the only one they haven't turned over. I mean, let's just talk that way. But what's most disturbing is, and I believe Your Honor should examine this, is the statement that was insisted to be included by Ambassador Everts concerning the conduct of this investigation by the SPO. And he wrote in his statement, talking about the interviewing process coming from the SPO, while every single paragraph is accurate as written and can stand as it is, the totality of the statement seems to reflect a lesser interest in exculpatory than incriminating information. If he was sitting here before you, Judge, as he would tell you what he told us, that the only thing that they were interested in, the SPO, was garnering what they considered to be inculpatory facts as opposed to exculpatory. How can they be fulfilling their Rule 62 obligations with such an approach? And as I noted, Judge, this is not an isolated incident. Oh, by the way, with regard to what they didn't turn over, I'm sure they didn't turn over a letter they got from the United States State Department during the same time frame, dated May 4th, 1999, from Barbara Larkin, the Assistant Secretary of Legislative Affairs, to Senator Mitch McConnell, Chairman of the Foreign Operations Committee. What did the United States, in an official document, tell a ranking senator in the United States Senate? There is no political structure in Kosovo or effective command and control of the KLA. They had this document. Did they turn it over? No. And I'd gladly give Your Honor a copy of this letter if Your Honor would like to see it, because I do have extra copies. There are any number of individuals that they haven't turned over. In paragraph 13 of the indictment, the Prime Minister, former Prime Minister of Kosovo, was an individual by the name of Buhar Bukoshi, B-U-K-O-S-H-I. Mr. Bukoshi gave us talk to the SPO. The interview ended with the statement questioned by the SPO interrogator. Oh, you must be friends with Hashim Thaci, aren't you? We never received that document. We never received any notes of any interview, whether or not he signed a document. He's mentioned in the indictment. We've received nothing. Hundreds of KLA soldiers were called to give statements. Where are all those statements? Where are those statements of what they said? We've got statements that the prosecutors put in their witness list that they believe are inculpatory. Where are the rest of them? Literally hundreds of people were called to be examined by the prosecutor. The most egregious matter here is the situation with Ambassador Evarts. Here is an ambassador, a ranking ambassador for OSCE. I submit to Your Honor that when the prosecutor was talking to ambassadors in a private meeting and talking about how terrible my client was and that my client was going to spend the rest of his life in jail, that he never informed them, did Mr. Smith say, oh, by the way, one of you ambassador folks? I mean, well, he says really, Thaci's not guilty and there really was no top-down involvement here, and this was just a grassroots movement. Do you think he told those people that? No, of course he didn't. He didn't even tell you. He didn't even tell you that the evidence that they had in their possession, it proves that they are not guilty, that there is a reasonable doubt concerning all these, but they keep and they hold him in jail indefinitely. What's the resolution here, Judge? There is one resolution we put on the table. That the search through exculpatory material, anything that's marginally exculpatory, has to be done by an impartial tribunal, because the SPO can't be trusted to do it. They cannot be trusted to do it. And they haven't done it. If they stand before you and say, well, we gave the information concerning, Evarts as soon as we know. Nonsense. Nonsense. They had first of all, they knew about this years ahead of time. Did they come to Your Honor and say, we have to delay disclosure of this exculpatory material? No. Did they have the green light to disclose this material? By their own admission, they had it earlier in 2021 at the latest, and the rest of the OSCE witnesses that they think are inculpatory were turned over. Were turned over in August of 2021. The only one they left out was him. Why? Why did they leave him out? And why did it take Ambassador Evarts to go to the Special Prosecutor's Office and request his statement on numerous occasions over the telephone and ratcheted this up as early as this Monday for them to come back in a series of emails, which I can provide to Your Honor, telling Ambassador Evarts, no, you can't, an international ambassador, you can't have your statement. It's not our practice, and the rules say we can't give it to you. I mean, who knows what rule that is? So where are we, Judge? Where are we? Your Honor has stressed several times about the need for them to go through and find their exculpatory material. Is there anything more exculpatory than this statement by Ambassador Evarts that they've known about for years? If there is, we're in serious trouble. And what we don't know, because the Evarts statement has essentially been forced out of them, we don't know how much more information there is that they haven't disclosed. They've been in jail since November of 2020. This is now February of 2022. And we were just given this information on the 1 February of 2022, while these four gentlemen sit at the detention unit, while they hide behind their refusal to talk in public about what they say about the Kosovo police and pretrial release, and refuse to give exculpatory information until they're forced to do so. It's got to stop, Judge. With all due respect, it has to stop. And I submit to Your Honor, and I just want to have my colleague Ambassador Prosper add a few comments. I submit to Your Honor, I don't know what the schedule is of the court, but there has to be an impartial magistrate involved in this disclosure process with the SPO, because they simply cannot be relied on and trusted to give full disclosure in a timely manner to ensure that these four gentlemen are not spending 1 second more than they should in the detention unit. And if I can just turn the floor over to, with court's permission, briefly to Mr. Ambassador Prosper.
Thank you, Mr. Keogh. Briefly, Mr. Prosper, because Mr. Keogh already took the floor for more than 15 minutes.
Well, Your Honor, I'll be as brief as I can, but this is a critical matter, and I ask your indulgence. As you know, I don't take the floor much in these proceedings, as we have my able colleague here, but I feel the need to address this issue because this matter has grave implications. It has implications which are broader than these proceedings, broader than the KSC. The implications are such that it shatters, it shakes the foundation of the international justice system. Now, I'm uniquely positioned to speak on this issue because, as you know, on my background, I've been involved in every single tribunal that has been created since Nuremberg. I either participated, negotiated, created, was consulted, or oversaw each tribunal. That includes the ICTR, the ICTY, East Timor, Sierra Leone, Cambodia, the ICC, Serbia, Bosnia, Iraq, Lebanon. I've helped consult in the creation, and now this. These tribunals are built on trust. Trust. They are supposed to be the gold standard for the world. They are supposed to be a model that domestic systems look up to and should aspire to become. Political leaders universally want to set a goal for people to say, if you can be like the KSC, like these tribunals, they will not be needed. Nations, governments, put their faith in these proceedings because they're supposed to be beyond reproach. They're supposed to be proceedings that can survive scrutiny, legal, political, and historical. Nations such as Kosovo have ceded their sovereignty voluntarily based on this trust. The trust of the establishment of the truth. They're supposed to operate with the highest integrity. And what has happened here is the prosecution has betrayed that trust. The prosecution has betrayed their duty to establish the truth. When they approached you for confirmation, they gave you a half story, which has led us to where we are today. In their zeal for victory, In their zeal for prosecution, they have lost sight of the most critical function of the office of the prosecutor, and that is the pursuit of justice, what is fair and what is right. Instead of letting the facts lead to the outcome, they've decided to bend the facts for their desired purposes. Now, this is a human rights violation, if you think about it. If you look at all the human rights instruments, you start with the Universal Declaration. What was the common theme or purpose behind this? It's to prevent abuse of power. It's to protect individuals. It's to protect accused persons from rogue prosecutions, rogue judicial systems. The purpose is to establish standards so that the truth and fairness will prevail. Now, the Office of the Prosecution has been operating without oversight. As you know from your experiences, one of the big debates for international tribunals is the question of oversight, because everyone's afraid of what is happening here, where you have a prosecutor's office operating on its own whim, unaccountable to anyone. As my colleague has said, disclosing when they wish, filing when they wish, sitting on critical exculpatory information for 4 years and not even giving it to you. To you. It's a deception that needs to be corrected. Imagine if what we are talking about happened in a domestic system. Just imagine the condemnation that would occur from human rights groups, from governments, from overseeing international tribunals. They would say, how dare you withhold critical, credible, exculpatory information? And as my colleague said, this is just what we know. This is only what we know. So what we have here, as I said, this is something larger than this tribunal. Because if this is allowed to continue, ask yourself this question. What country in the future, what country in their right mind will ever agree to an international or hybrid tribunal when they learn of the behavior of hiding exculpatory information, when they learn of the behavior of not pursuing the truth, the establishment of the truth, when they learn of the behavior of deceiving the court? Who would want to be part of an international tribunal? So, Your Honor, this is a large issue that needs to be corrected. The KSC has lost its way. And if this is not corrected, the legacy of this court, the legacy of the officials, the legacy of international justice will forever, irreparably be harmed. So let's put this into context. This is not just a little issue that needs to be addressed in a status conference. This is much larger. Thank you for your time.
Thank you, Mr. Prosper. I'll give the floor to the SPO after I gave the floor to the other defense team to respond to the arguments. May I just turn to the interpreters? Do you allow me to continue for a couple of minutes so we can finish the debate on this category of disclosure material? I see the court officers saying yes, so thank you very much. Let me turn to Mr. Emerson, please.
I'll be brief, if I may. There are two issues that I wanted to touch upon, but the first I'm going to leave until the any other business section, and it relates to where we stand in terms of the prosecution's served witnesses. And that is to say, even though there remains considerable uncertainty about the unserved evidence, of which the statement of the ambassador to the OSCE is a good example, but the numbers you've been quoted this morning make it fairly clear we won't get to a certainty about the prosecution's case and the scope of it for at least another few months. But what I want to do with you, sir, at the end of any other business section is just to spend a moment or two tracing through the implications of the way the prosecution is proposing to put its case. and the number of witnesses it is proposing to call. But I think that is although it touches on some of these issues, I think that's best dealt with at the end. And on the detailed questions of exculpatory, I'll just give Annie O'Reilly an opportunity in case there's anything she wishes to add. But otherwise, I'll return to the main issue that I wanted to raise with Your Honour at the end of the status conference.
Thank you, Mr. Emerson. Ms. O'Reilly.
Your Honour, I'll be brief. We join the submissions made by the Thaci defence. The issue of Rule 103 disclosure is very serious, and as we have previously raised in protective measures submissions, we have no faith in the SBO's identification of 103 materials. I would say their ability to, but given the experience on the other side of the courtroom, I don't think that would really be credible. They are simply not disclosing 103 material to us that we are entitled to. We are aware of other witnesses who fall into the category of Mr. Everts that have also not been disclosed to date, that have provided potentially exculpatory information. So I would just like to underline that this is an incredibly serious matter that really goes to the heart of the fairness of this trial. As regards to our request for some clarity as to how much 103 material there might be, we would note that we still have not received an answer to this. We were told that there have been 21 packages disclosed so far. For the sake of the record, that comes to a total of 3,583 items. But that we don't know if they've reviewed everything that they received up until recently. All we've been told today is that they've gone through 50% of the materials that they've recently received. So we would request some more specific information in response to our question. Thank you, Your Honour.
Thank you, Ms. O'Reilly. Mr. Young, please.
Yes, Your Honour, I can be brief as well. What Mr. Kehoe, on behalf of Mr. Thaci, has related to you is extraordinarily serious. We support and endorse every submission the Thaci team make, and it must be apparent to Your Honour how serious this issue is. Indeed, Your Honour, at the start of the discussion on 103 materials, rightly acknowledged that the important words in Rule 103 were "as soon as." And as Your Honour knows, and Your Honour is rightly nodding, the words then follow: the specialist prosecutor shall immediately disclose to the defence any information as soon as it is in his or her custody, control, or actual knowledge which may reasonably suggest the innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence. Now, Your Honour rightly described this category of disclosure as absolutely crucial for the defence investigations. And the material that Mr. Kehoe has referred to clearly falls well under that category. Now, there are a number of disturbing things about what we've heard in relation to this, but Your Honour will have noted that that Mr. Kehoe explained this particular extraordinarily important document from an extremely senior international figure. That document was a document produced by the prosecutors themselves in January and March 2018, over 4 years ago. So with respect, difficult to see how they weren't aware of it, given that they were the ones that produced it. And Your Honour will know very well that 103 is subject only to two restrictions where delayed disclosure can be made. And these are very specific ones under Rule 107 and 108, which do not appear to apply or appear not to apply in this situation, because if they had applied, the prosecutor would have had to apply to you formally, ex parte and confidentially, in an application, and you would have knowledge of that. In the absence of any application to Your Honour, then there seems to be a gross, substantial and egregious violation of the disclosure rules, which are so important to the defence. And for these reasons, we ask Your Honour to take this particularly seriously and to follow the Thaci submissions in relation to what they requested, which were very clearly set out. So I have nothing else to say. This is a very serious matter.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, we too join in what has been said already, particularly by all three defence teams, and particularly the Thaci defence. This is a matter that concerns us all, Your Honour. Certain passages have been read from the statements of Mr. Everts. They're exculpatory not only for Mr. Thaci, for all the accused, and certainly for Mr. Krasniqi. We are deeply concerned that these statements were not turned over at a far earlier stage in proceedings. We cannot understand how this can fit with the Rule 103 obligation to do so immediately or as soon as in the prosecution's control. And that is what this must come down to, the wording of the rule, and it appears not to have been complied with in a very serious way. And we are also concerned that this is one example that's been given to Your Honour. Glancing through disclosure batch 160, which was the one disclosed on the 1st of February, one can see at a cursory glance statements taken by the Special Investigative Task Force in 2014, interviews carried out by this prosecution in September of 2020. None of those documents can be said to have been turned over to us as soon as they were in the prosecution's possession. They were in the prosecution's possession when they arrested these men. They should have been turned over shortly after that. And we, again, emphasise the seriousness of this, Your Honour, and we look to Your Honour to protect our clients' rights in this regard.
Thank you, Mr. Ellis. Let me turn back to...
Your Honour, before Your
Mr.
Honour
Emerson,
continues,
yes.
could I do apologise, but could I invite you, please, to ask the prosecution now to explain the circumstances on which that document was withheld for this length of time?
Thank you, Mr. Emerson. So, Madam Prosecutor, you have the floor, both to respond to the specific document that was partially read by Mr. Kihu, the reasons for such a late disclosure, and more generally on the disclosure process for the Rule 103 material. You have the floor.
Thank you. In relation to the Rule 103 material status and the Vasselli defence query on that, yes, prior material such as that on the Rule 102.3 notice has undergone an exculpatory review. We're now reviewing material more recently received or cleared, and as I mentioned, we're over 50% through that review. Turning to the Thaci defence, if I understand their submissions correctly, Mr. Everett's statement appears to be the item that they were interested in. I'm obviously only learning that now for the first time, as I am only learning now that Mr. Everett has any connection to the Thaci defence team. This obviously hampers my ability to respond with any degree of specificity on this one item out of the over 170 that were included in recent Rule 103 disclosure packages. What I can say is, first, that the defence have chosen to quote very selectively from the views of one individual. Should the defence choose to present that evidence at trial, its value will be assessed in the context of other evidence. Second, recent Rule 103 packages were determined by ongoing review and not by any outside query. As to the timing, for many of the materials disclosed in recent 103 packages, we would have initiated clearance requests as early as 2019. We've been diligent in seeking clearances, in following up with providers, and in subsequently making relevant disclosures. What disclosure of this item does reflect is that the SPO is correctly identifying and disclosing exculpatory material. Much additional exculpatory material has already been disclosed, and additional exculpatory material will be disclosed. That information can be used by the defence to develop their defence cases or identify leads. That's the purpose of the disclosure. As I mentioned, evidence the defence choose to bring will be considered in the context of trial, will be weighed against all the other evidence, including that presented by the prosecution. Mr. Kyo also referred to a second specific interview, and I can say that he has inaccurately summarized it. From the responses we received during to to our indications at the last status conference and our recent inter partes communications, it would appear that the defence are less interested in actually receiving these items than in making submissions about them. We will continue our review and disclosure of potentially exculpatory information as we have been doing, and we're working intensively to complete it. Thank you.
Thank you, Madam Prosecutor. Briefly, Mr. Kehoe, please. Microphone.
Yes, it is difficult to stand by and listen to what the prosecutor just said. What I gave Your Honor was I read what the prosecutor turned over. Everett's view was that the criminal activities post-June 1999 were committed by individuals who sought a chance to gain personal benefit and was not part of an organized campaign from the Albanian leadership. This is not some commentary by the Thaci team that is trying to take some debate about the disclosure. This is the problem, that it wasn't disclosed. When Your Honor was making rulings on the pretrial release of these four gentlemen, would Your Honor not want to know that an OSC ambassador that ran the OSC office during the operative time frame of this indictment said that this violence was not part of some plan by the Albanian leadership, that my client, Hashim Thaci, had no motive to encourage this type of conduct. I am paraphrasing. I'm gladly read once again, Your Honor, which I did before. It wasn't Greg Kehoe talking. What I read to you was from the statement. But I will gladly reread what is in this statement and this exculpatory information. It's an outrage that they sit there smugly and don't take responsibility for keeping these four men in jail when they had documentation before them that indicated there was reasonable doubt about this case. And how about their arguments that if you release any of these four men, they're going to go down and wreak havoc in Kosovo? When they said, their witness that they took the statement from, Ambassador Everett, said, there is no incentive for Mr. Thaci to do any such thing, and what would happen in their relationships to the internationals. This document wasn't turned over in the due course of their 103 case. I can tell you exactly what happened. Let's back up. The OSC witnesses that were inculpatory were all turned over. They got clearances and they were turned over in August of 2021. We've had 2 pretrial detention motions since then. Everett's was at the latest, was received at that point. They even say in their memo that clearances were received in the second half of 2021. August is 2021. So it's okay, gentlemen, to stay in jail for August, September, October, November, December, January, until the SPO decides to get around to turn this document over. And why did they turn it over? And by the way, Judge, the Thaci defense has got no relationship with Ambassador Everett. Ambassador Everett is a gentleman that came out in these OSCE reports. Ambassador Prosper called him on the phone. That's how it happened. Called him on the phone and said, can we chat? As far as any relationship with the Thaci defense, there is no relationship. And if he sat here before you, he would tell you that. But we talked to him as a result of that. And it was as a result of our first conversation with Ambassador Everett where he expressed some surprise that we did not have his statement, that he articulated this. I think I'm going to contact the SPO to see if I can get my statement. That's what he told us we were going to do. We had no control over Ambassador Everett. This is an international ambassador of some stature, Your Honor. And that's what he did. He attempted to contact the prosecutor who took it, who apparently had left the office. He then attempted to contact people in the office that he knew. That gentleman said, I'm going to see what I can do. And when was that? The last conversation of the person inside the prosecutor's office, Mr. Bennett, as to turning this document over was Monday. It was Monday. And it was at that point that the SPO concluded that they had been caught. That they had been caught in not disclosing 103 material. Material that, at very minimum, under the best of circumstances, from anything the prosecutor said, will certainly affect the credibility or reliability of the special prosecutor's evidence. And it was thereafter that he tried to get it that the SPO said, we're not going to give it to you. And then, oh, okay, then graciously, within 24 hours, it just happens to be uploaded. Just happens, miraculous, out of the ether. This document that is such an issue happens to be uploaded. So, well, you know, it's just the natural course of things. Nonsense. This is nonsense. Does anybody believe that story? Of course not. Of course not. They turned it over because they had been caught. And the problem here, Judge, is not necessarily the document. It's the problem is that those 4 men are still sitting in jail. Well, they sat and didn't turn anything over until they got caught. That is the problem. Putting aside the problems that Ambassador Prosper outlined. That is the problem for my client and these gentlemen and ladies' client. And I submit to Your Honor that based on this alone, there is reasonable doubt, and this court should release these gentlemen on any conditions that Your Honor wants, but release them. Because a senior member of the international community has put everything that the SPO has leveled in this indictment in doubt, in reasonable doubt. And you can't hold somebody in jail indefinitely based on that. Thank you.
Thank you, Mr. Kihu.
Your Honor, can
Mr. Prosecutor, very briefly.
I only have a very brief question just to get the record clear. To the defense, you just made a submission that there is no relationship between Mr. Everts and the Thaci defense. Is it your submission that there is no relationship? Does that include Mr. Thaci, or are you separating the Thaci defense from Mr. Thaci? Is it your submission that there's no relationship between Mr. Everts and Mr. Thaci?
I'll tell you, they want to accuse, they want to accuse us of some type of improper conduct. I'll take that on all day long. All day long. The contact with Mr. Everts came about because we were viewing these documents to see who was in the theater at the time. There is, in fact, a book that was written by the OSCE, which has 2 sections to it. And what happened? What happened with regard to Mr. Everts? There was no instruction. I don't even say this. There was no instruction from our client to contact Ambassador Everts. We went through who the ambassadors and the internationals were, and guess what, Judge? We have a member of our team who worked in the international community, Ambassador Prosper. And Ambassador Prosper was the gentleman who contacted Ambassador Everts, and we started this conversation. Period.
That's noted. Thank you.
I'm not at all making any allegations. I'm
Yes,
just
you
trying.
are. Stop
I'm
it.
just,
Stop
I'm
it.
just
Yes, you
asking a question to understand your submission, and you didn't answer the question.
Don't ask a question like that if you're not trying to level some personal allegations.
Could the speakers please not overlap, because it's impossible to have an accurate transcript if you overlap. Thank you very much on behalf of the interpreters.
And I advise all the parties to follow this advice. Now, let me, before we go into a short break, do you want to say something? If so, very quickly.
I do briefly want to respond on process, because what the Thaci defense said...
I'm so sorry. I've been trying to get the floor for a while.
Sorry, Mr. Emerson. Let me first give the floor to Madam Prosecutor. I'll give you...
You might want to deal with the point I'm going to raise, that's all.
Madam Prosecutor, can I give the floor to Mr. Emerson? Very briefly, Mr. Emerson, please.
Yeah, it's a very brief point. A number of the counsel for the accused, including Ms. O'Reilly on behalf of the Basili defense, asked for a clear indication of how much exculpatory material is still in the possession of the prosecution without having been disclosed. And it's crucial that we know that, because we're about to move on to an agenda item about defense preparation. And, you know, are we dealing with the volume of material which we're having to deal with still yet to come, particularly, as you rightly say, the exculpatory material, which is vital for planning the defence investigation, we can't leave this status conference without a number from the prosecution. They must know what they've got.
Thank you, Mr. Mason. Madam Prosecutor.
Thank you, Your Honour. I did just briefly want to respond in terms of process, because what the Thaci defence said is not correct. The Rule 103 packages were prepared last week as part of ongoing review and disclosure. And as for its weight, as Mr. Keogh said himself, they are positing the views of one individual against a substantial body of other evidence. Thank you.
Thank you, Madam Prosecutor. So before we have a short break, first I want to invite the SPO to continue its review of material as fast as possible. And as I said earlier, it has to be the priority. Exculpatory material has to be the priority. It is essential for the defense, and it's also essential for the court, that these documents, items are disclosed as soon as possible. I also ask the SPO to inform the defense, inter partes, and then the bench before the next status conference, of the state of review of the material that the SPO has under its control or possession. It is important for the defense to know exactly where we are. I note that you've indicated that 50% of the material had been reviewed. I don't think it fully answers the question of the defense in terms of number. So I invite to continue the discussion and to inform regularly the defense on the quantity of material that still need to be reviewed. And finally, I note that the Thaci defense indicated that one option could be to have a third party examining the material in order to determine if exculpatory material would be in the possession of the SPO. I invite the Thaci edition for a written filing on this issue, if it wishes, especially on which legal base and which modalities, because this will have to be dealt with in written rulings, given the complexities of such a proposal.
Yes, Your Honor.
Thank you, Mr. Kihu. We're going to have a short break. It is 4:26. I remind the parties that, as usual, we need to finish at 6 p.m. at the latest. So I invite all the parties to be brief in the second part. We're going to resume at 4:50 hack time. 4:50 hack time. The hearing is adjourned.
All rise. All rise. Please be seated.
So let us move to the last category of disclosure, which is the Rule 107 material. I note that in its submissions, the SPO is continuing to actively work to complete discussions with Rule 107 providers. The SPO notably indicated that 2 filings would soon be submitted once relevant discussions with providers in relation to any proposed counterbalancing measures to be proposed in those applications are concluded. I invite the SPO to make submissions on this category of material. Madam Prosecutor.
We are very much working to complete discussions with relevant Rule 107 providers. For those with whom clearance decisions are outstanding, we continue to be in contact with many of them multiple times a week, often going through individual documents with them in a detailed manner. And as a result of these efforts, significant further progress has been made, and for the vast majority of items, clearance decisions have been reached. Yesterday, we submitted a Rule 107-2 request, which was notified this morning as filing 678 in respect of 21 documents which had ultimately been denied clearance by 2 providers. There are further Rule 107-2 requests that are being prepared, and for one, we're completing discussions on possible counterbalancing measures, as you mentioned. The filing we submitted yesterday also contains an overview of the providers that we remain in discussion with. So as the court will have seen, relatively speaking, this is not a large number of items. We hope, and based on timelines that have been indicated to us, we do in fact expect to conclude many of those discussions in the coming weeks. Should there be a need for any further application at that time, we will do so. Thank you.
Thank you, Madam Prosecutor. Do the defense team wants to take the floor on this category of material? Mr.
We have
Kihu.
nothing on this issue, Your Honor.
I don't see any request for the floor. Okay, so then I will move to the next item on our agenda, which is the issue of translations of filings and evidentiary material. I would first like to hear from the registry on the progress made with regard to the translation of these items, notably whether the parties have made any further urgent requests for translation, and whether the registry can give an estimate for the translation of the SPO pretrial brief and related material and Rule 109C chart. I would also like to hear the parties on any further difficulties regarding translations and if there are any filings that needs to be prioritized. I will first give the floor to the registry. Mr. Nielsen, please.
Thank you, Your Honor. So as set out in our written submissions, translation of the pretrial brief is well on track. And a revised Albanian translation, both the strictly confidential and the confidential redacted version, will be finalized by 18 February. By the same date, we will have completed the unrevised translation of the witness list. And beyond this, there are no outstanding prioritized requests before the LSU. With regard to the Rule 109C chart that you had asked about as well, Your Honor, we set out in the written submissions the challenges with regard to this document. I will not repeat those submissions, but just to add that should there be a request for prioritizing this document, we would ask the parties to be as specific as they can be when it comes to which pages and which sections that is of most interest for them, and that will assist greatly to bring some focus to that translation task. Again, only if there is a wish to make this a priority. Thank you.
Thank you, Mr. Nielsen. Mr. Kihu, please.
Yes, Your Honor, we have nothing further on this topic. We understand the position of the registry, and we, of course, will prioritize items as requested by Mr. Johansson.
Thank you, Mr. Kihu. Mr. Emerson, please.
Unless there's an indication from either of my trial colleagues that there's any issue they wish to raise, I don't think there is anything we need to address you on.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, we would regard the Rule 109C chart as a priority of ours. We'll consider the point made by my learned colleague for the registry as regards prioritisation. My initial view would be it's a very difficult document for us to prioritise, and Mr. Krasniqi would need to see all of it. But we will give that further thought, Your Honour.
Thank you, Mr. Ellis. Mr. Laws, do you want to mention anything on that topic?
No, thank you, Your Honour.
Thank you, Mr. Laws. Now let me turn back to the SPO to ask about the status of its ongoing investigations. Since the last status conference, the SPO filed its pretrial brief and related material pursuant to Rule 95. It also filed its Rule 109C chart on 28 January 2022 as ordered. In its written submissions, the SPO indicated that SPO investigations in fulfillment of its mandate are anticipated to continue for the foreseeable future. However, the SPO did not indicate whether investigations could be completed by 4 March 2022, as I suggested in this scheduling order. I would like to insist on the fact that the factual basis of the case of the SPO shall be set before trial, and that SPO investigations in this case should largely be completed by the time the case is transmitted to the trial panel. General investigations should not continue throughout the trial. There needs to be a case file that is properly transmitted to the trial panel. Rule 1024 confirms that objective. Only under exceptional circumstances can additional evidence be disclosed and subsequently used at trial. The defense cannot be expected to prepare a defense on a case that is constantly evolving. So I would like the SPO to indicate whether it can provide a further update on the estimated date of completion for outstanding investigative steps and the nature of these investigations. I also invite the defense to present their views on this topic. Madam Prosecutor, please.
Thank you, Your Honour. We have heard your direction just there, and we confirm we are aware of that framework. However, I don't have much to add to the submissions that we've made at previous status conferences. It remains the case that it is the responsibility of the office to continue to investigate within its mandate, and should such further investigations result in material we seek to rely on, we're aware that judicial authorization will be required. Or if the material is exculpatory, that could obviously only assist the defence, and we would otherwise comply with any disclosure obligations. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Your Honor, consistent with Your Honor's statement to finish this investigation, obviously that has to be done. This can't go on forever. And I remind the court of our Ori Tennis motion under Rule 47 to terminate the investigation. If they're out there investigating some other matters, it's been going on for a significant period of time. The law in Kosovo permits it to go for a very limited time. We are well past that. So we reiterate our Ori Tennis motion, which we'll gladly put in writing, to terminate this investigation under Rule 47.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honour, first of all, we're grateful for the instruction that Your Honour has just given, which at least provides the certainty that there will be an endpoint to this exercise. Obviously, all of this has an implication both for the defence investigation and for the process of referral to the trial chamber, when that should be. And as Your Honour made the point a moment ago, that process needs the transmission of a complete case file with the substantive allegations properly clarified. I'm going to be saying something, as I said to you earlier on, about what the case file is currently going to look like and whose responsibility it is to prune it down.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, nothing to add. Your Honour may remember that I think it was the first status conference. Yes, you've got it. I used the guillotine word, a French word, and it's about time that we knew the date of the execution.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, we agree with that. We've heard exactly the same submission from the prosecution at probably every status conference in this case. It can't go on indefinitely, Your Honour.
Thank you, Mr. Ellis. Madam Prosecutor, do you want to add anything?
No, thank you, Your Honour.
Let me just stress that we have a legal framework and additional evidence will only be admitted with a very strict scrutiny from the panel and really in exceptional circumstances. I think it has to be clear on the record. Let me now move to the next point on the agenda, which is defense investigations. Having received the SPO pretrial brief and the Rule 109C chart, as well as the majority of the Rule 102.1b material, I would be interested to hear the defense regarding the status of their investigations, in particular, whether they can provide information on the status of their investigations, whether the defense has any intention to make requests concerning unique investigative opportunities, whether the defense can provide information on any intention to give notice of an alibi or grounds for excluding responsibility, whether the defense can provide a best estimate of when it would be prepared to file its pretrial brief. I note the defense submissions that difficulties remain with respect to investigations. However, even if the defense is not in a position to give details on their investigations and upcoming requests, I invite the defense to provide an estimate on the expected lengths of their investigations and when it anticipates being in a position to file its pretrial brief and related material. And I also invite the defense to indicate if they do not wish to file a pretrial brief according to Rule 95.5. Mr. Kihu, please.
Yes, Your Honor, you outlined some of the problems there are extant with regard to this investigation, not the least of which is the ongoing COVID pandemic, but also take into consideration the extensive amount of information we have received over the past month or so, not the least of which is on January 31st. Take that on top of something I highlighted previously, which was there are 326 proposed witnesses. 106 are anonymous, though we don't even know who they are. And we may get some prior to trial. It looks like we're going to get some in the middle of trial. It makes this investigation extremely difficult. That's not saying that we're not in the field attempting to investigate this, Your Honor. We are. But it is much more time-consuming with those types of constraints. Because if we knew what the information was concerning many of the allegations, certainly these crime-based allegations, we could dispense with them somewhat quickly. In many instances, I'm sure. But we're in the unfortunate position of trying to guess exactly what transaction they're talking about and going from there. Extremely time-consuming. Extremely time-consuming, that in conjunction with with the trial brief, with the amount of information that was in the 109C chart. I'm sure Your Honor can understand exactly how long it's going to take. Can I give you an estimate at this point as to how long that investigation is going to be? I can't. We'll try to revisit that during the next status conference, Your Honor. I will give you my word. We will go through the investigative team and try to talk to them as to how much time they think they need. I think that their estimate is going to be quite extensive, but I don't want to speak for them before I get a firmer or more definitive statement as to how long it's going to be. With regard to the Rule 99.1 issues and taking testimony from individuals, we are in the process of attempting to do that now, and I think that that is going to become before Your Honor, or maybe the three-judge panel, the trial panel, unsure, relatively soon, because given that the prosecution has put 1,864 hours on the table as far as how long this case is going to be, and I know Mr. Emerson is going to address that issue. Some of these individuals are not with all due respect to them, are not young. And not Mr. Young, I meant in ages, in years. So some decisions are going to have to be made in the very near future concerning some of those witnesses that are of advanced age. I wish them a long life, Judge, but I don't wish them any ill. But the practicalities are such that if this trial is going to go on, which what looks like years, then we're going to have to take some measures to secure that testimony. And we have not done that definitively yet, but I'm just going to put it on the table so Your Honor can consider it that we will in fact do it. With regard to the alibi defense, I can tell you that much, again, we go back to the amount of redactions and we go back to all the information that's in the indictment that we don't know. What I can tell Your Honor at this point is that my client was, Mr. Thaci was out of the country for long periods of time throughout the 1998-1999 period when I assume, because we don't have dates, some of this activity took place in Kosovo. So to the extent that that comes into play when we have a more definitive date time frame from the SPO, I am sure that we will be putting forth an alibi defense on various transactions. I'm sure of that. I just don't know which ones they are.
Thank you, Mr. Kihu. Mr. Emerson, please.
Yes, I'm going to ask Mr. Strong to present our submissions on the defence investigation. He is, as I said earlier on, in court with Counsel Kwitim Kereveshi, who is also heading up the Kosovo-based investigation and advising on that.
Thank you, Mr. Emerson. Mr. Strong, please.
Yes, thank you, Your Honor. The Vercelli defense has started its investigation, as we've stated at previous status conferences. We faced similar issues as the one my colleague, Mr. Kehoe, outlined. And I think more importantly, the investigation is proceeding in fits and starts, where we'll start down a road with an issue, and then we'll get a batch of disclosure that's 2,000 documents, and we'll have to stop and process it, and it reshapes how we're thinking about the issue. So that's a challenge, along with just the scope of the case. I'm sure Your Honor has seen with the pretrial brief, there are 16,000 proposed exhibits that we're currently working through. As you've just heard with Rule 103, we're still waiting for, I believe, about 50% of the material that they still need to review. And we still don't have an estimate as to when we can expect to have that material, which is going to form the foundation of our defense case and our defense strategy and our investigation plan. So we will make all efforts to continue this investigation under those circumstances, but given that reality, we're not in a position to provide an estimate in terms of when we could reasonably expect to end. We don't see a need at the moment for a special investigative opportunity. However, we reserve the right that could change should the need arise. And I think with the other issues, just we can wrap them up all in one submission here, that the position remains largely the same until we see more of the 103 material and have had more time to go through the volume of the prosecution's disclosure. We're not in a position to put in a reasonable estimate in front of you. Thank you.
Thank you.
Can I just add one point of detail,
Mr. Emerson.
which I just wanted to ensure that Your Honour had in mind, which is that you've asked us to do our best to give you an estimate of how long the investigation is liable to take. And obviously, we're keen to do that at the earliest possible moment. But if you take the issue that you have just earlier on ruled upon in relation to the witness protocol, in other words, written submissions possibly followed by an oral hearing on the 22nd, the outcome of what is agreed on in that respect is going to have a massive impact on how long things take. Because if I'm sure you're very familiar with the process that's envisaged by the protocol, but it involves us writing to the prosecution, who will write to the witness, see if they've got any objection, and then make an assessment and if appropriate, organise a meeting where the witness has to travel at their own expense to The Hague, and then finally can meet us in the presence of the prosecution. Well, that's an extraordinary handicap for any defence to be under. I've never heard of anything remotely resembling it anywhere with no evidential basis, just a presumption that that is the approach that's going to be taken. The prosecution have interviewed all these people on their own and have made decisions apparently about which ones they were going to sit on, like the ambassador's witness statement. But the defence must play their hand entirely open. Well, that's going to have an impact on whether we have a fair trial, because it's going to have an impact on whether we think it's appropriate to interview a witness if we have to have the prosecutor sitting in on a defence case. Clearly, if there were real concerns about a witness, then there could be alterations made. But my point is a simple one, is that the investigation might be one that takes 9 months or 12 months if there was no such argument. But if we're going to work in that protocol, I would have thought you're looking at a 2.5-year investigation.
Thank you.
A massive impact on the pre-trial period.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, Your Honour, very briefly, in relation to defence investigations, as I mentioned on the last occasion, we've commenced investigations. All I can say is they will clearly be, this will clearly be a lengthy process, and it's very difficult to give an estimate as to how long defence investigations will take, particularly given what we mentioned earlier, that there's still, there's still a huge amount of material to analyse and digest. We've just received, as Your Honour knows, the pre-trial brief. So we're diligently reviewing the pre-trial brief, the underlying materials. That task in itself will take months, frankly. In relation to disclosure generally, Your Honour knows that there's still a massive amount that we still don't have. And if we're going to be given the 102.3 materials that we've asked for, that's another 43,000 additional sets of materials. So it's very difficult to say at this stage. All I can say is we're very diligently going through everything we can as quickly as we can. And as far as the defence pre-trial brief is concerned, frankly, it's difficult to say now in the light of what I've just mentioned as to when we'd be in a position to draft one.
Thank you, Mr. Young. Ms. Alagendra, please. Microphone, please.
Your Honor, our investigations have commenced. They're ongoing, but it's too early for us to give any estimate as to how long it's going to take and as to when we will be able to submit our pre-trial brief. Our position remains, as has been submitted by counsels for the other 3 teams. For this reason, we are unable to give any update at this point, probably by the next status conference, Your Honor.
Thank you, Ms. Alagendra. I invite the defense teams to try to give their best estimate the next status conference as proposed by Mr. Kihu, taking into consideration the constraints that you all explained in your written submissions as well. Madam Prosecutor, do you want to say anything on this topic?
Only very briefly, Your Honour. We provided the defence with a list of over 300 proposed agreed facts in March 2021. Excluding translations, we disclosed approximately 95% of Rule 102.1b materials over 5 months ago. That is on or before the 18th of August. All of which was subcategorised in legal workflow. We provided a provisional witness list, including summaries, in October 2021, and we provided our pre-trial brief, witness and exhibit lists in December 2021. And we remain available to the defence teams to discuss any points of agreement. Thank you.
Thank you very much. I don't see any request for the floor. Let us now move to the date of the next Statutes conference. I confirm to the parties...
I'm so sorry, Your Honour, but as I indicated to you earlier on, I have a significant matter to raise with you under other business.
I know, don't worry.
Oh, okay.
This will be after the date for the next Statutes conference. I haven't forgotten. Now I just want to confirm that I intend to schedule the next status conference on Thursday, 24 March 2022 at 14:30 Hague time. So I invite the parties to confirm their availability. Madam Prosecutor.
Yes, Your Honor, we will be available. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor, we will be available. And as for the 22nd of February, we will be available for that date as well.
Thank you, Mr. Kihu. Mr. Emerson, please.
Yes, we'll be available.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, we'll be there.
Thank you, Mr. Young. Ms. Alagendra, please.
We are available, Your Honor, on the 24th of March as well as 22nd of February.
Thank you, Ms. Alagendra. Mr. Laws, please. Mr. Laws?
Your Honor, yes, we're available then. Thank you.
Thank you, Mr. Laws. Mr. Nielsen?
Thank you for asking, Your Honor. I'm certainly available.
You are administering the courtroom, so if you are not available, we cannot organize any hearing. You will receive a scheduling order that will include an agenda before the next session conference as usual. Now, at this point, I would like to ask the parties and participants whether they have any other issues they would like to raise. And Mr. Emerson already indicated that he wanted to raise a specific point, but let me go through the usual order. Madam Prosecutor?
No, thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Kihu?
Just the two items that I had talked about before, the pretrial detention issue and the obviously the 22 February hearing are the two issues that I wanted to address. The most important, of course, being guidance from Your Honor on pretrial release issues.
Thank you, Mr. Kihu. Mr. Emerson, you have the floor.
Can you hear me? Yes, good. Well, I'm grateful to Your Honour for ensuring there's sufficient time for me to address this question. I think it is a rather important question now that we have the prosecution's pre-trial brief, and as has just been said by the prosecution, a significant sense of the shape of its case. There is important stuff still outstanding, but there is sufficient disclosed to enable me now to take stock of the situation and to make some general submissions about the scope and scale of the prosecution case. Your Honour will remember that at an earlier hearing I had, in fact, I think at more than one occasion, anticipated that we were heading towards an unmanageable trial and that a solution needed to be devised for whether it is your responsibility to impose discipline on the prosecution or the responsibility of the trial chamber. But one way or another, something has to give. And because the tribunal is working out its own processes for the first time, there isn't a track record of experience. At the ICTY, generally speaking, the trial chamber would impose a limit on the number of hours and would require a general timetable that no witness should take more than half an hour unless the party wishing to question them had made an application, a reasoned application to the judge. So there are various things that can be done and importantly were done at the ICTY to maintain some sort of control. And obviously, as you know, in some of the cases, even that was insufficient. So, for example, Milosevic died during his trial because it had generally gone on so long because the prosecution in that case decided to try all three countries, in other words, Serbia's crimes or Milosevic's alleged crimes in relation to Croatia, Bosnia and Kosovo in one joint trial. But with that introduction, and I anticipate that the submissions I make are going to be met with a response, well, this isn't the ICTY. We are deliberately set up to do better than the ICTY, which was the submission they made, if you'll remember, when arguing that they would be trial ready in June 2020. I drew your attention to the timeframes that were taken in pre-trial proceedings in a whole range of cases at the ICTY and ICC, and I predicted that we would get to the end of last year and not be ready to start a trial, and based on the careful analysis of the practices and the time taken in the other cases. Well, this is water under the bridge now. We've moved through the pre-trial period, or we're moving through the pre-trial period. My only concern is that these accused were denied provisional release on the basis of a false representation to you about what the pre-trial period would be. I'm inviting you and the prosecution not to make the same mistake again, because it's undeniable that the prosecution has failed to get a grip on its case, and as a result, it's completely out of control. It's partly a consequence of them not having any direct evidence of crimes committed, incited, or participated in by any of the accused. It's all built on inference and argument from events that none of the accused were actually involved in any way in. And I think that does make it a more difficult case for the prosecution to advance. And therefore, a tendency is to throw in everything, including the kitchen sink, the baby and the bathwater, or throw it all in one big mush and hope that it lands. But the result of that process, just let's look at it for a moment. The prosecution has put time estimates for oral testimony on the witnesses that it is intending to call. I think I'm right in saying that cumulatively those time estimates come to something over 1,300 hours on prosecution direct examination only, right? So to put that in perspective, in the Milosevic case, the prosecution used a total of 360 hours to present its case, which included defense examination of prosecution witnesses. So unlike the prosecution in our case, which is asking for 1,300 hours for only direct examination, in the Milosevic case, the prosecution used 360 for direct and cross-examination of their case. And the case as a whole took 2 years. Right, so we're beginning to see 1,300 hours for this prosecution, 360 hours for Milosevic, and that case took 2 years before Milosevic died, but he died during the defense case. In the Perlich case, the prosecution used a total of 296 hours, so less than Milosevic, to present its case over approximately 1 year and 9 months. And one of the best timed cases was actually the Kosovo Crimes Against Humanity case, in which 5 Serbian political, military, paramilitary and policing leaders were all put on trial for jointly committing crimes against humanity in Operation Horseshoe, which was the operation by which Serbia encased the Kosovo Albanian population with a horseshoe of armed forces and then traveled through the country. This is in the immediate aftermath of the NATO bombing. Traveled through the country, driving Albanian civilians across the borders to Macedonia, Montenegro, and Albania. So it's a very, very significant trial in the same territory that we're talking about. And the lead case in that is Sinovic, or Milutinovic case, in which the prosecution used 166 hours, so 1/10 of what the prosecution is asking for here, across approximately 10 months. So they did very well in that case, I accept that. But the rate of trial, interestingly, in those 3 cases is consistent. There's a pattern, right? With the very tightly managed way that ICTY handled these cases, there's a broadly consistent pattern with a relationship between the number of witnesses, the number of hours, and how long the trial takes. And at that rate, if you apply it to the witnesses that the prosecution have put forward in this case, it would last something like 120 hours, sorry, 120 months. Prosecution case would last approximately 120 months. So, somewhere near 10, 11 years for the trial. Right? And supposing there's a defense case cut to its absolute minimum, that would be likely to be 18 months, 2 years. So you're talking about a 15-year, potentially, 15 year trial. Now, in addition to the witnesses on their list, the prosecution has proposed 16,000 exhibits and the total number of witnesses being 345. But the figures I gave you in hours were for those they have indicated they intend to call by verbocci. And it's no good the prosecution saying, well, if the defense was prepared to agree on this, then we wouldn't need to call any of the evidence in the case. We could just do it on paper. Well, we're not. And that's not going to happen. So the prosecution needs to be in a position to buckle up and prove its case. And if the case it's trying to set out to prove now is the one that is permitted to go to trial, it will last at least 10 and probably more than 12 years. Now, that cannot be in the interests of justice. It undermines international criminal law fatally. It undermines anything good that this court is trying to do. It undermines the justice for the accused, as well as justice for the victims, as well as justice for the witnesses. It's a disastrous proposition, and it makes the court a laughingstock. Let's be honest. There's already considerable concern about the way the court is conducting itself, but that would make the court a laughingstock. So somebody is going to have to tell the prosecution how to run their case and how to cut it down to a manageable level. It's meat and drink for judges in international criminal courts. They do it all the time. That's the way the system works. And if it doesn't work that way, these trials are not achievable. So unless you do something about this, this will be the last international criminal tribunal that's set up. And as far as that's concerned, we've begun the process of trying to see how you would edit the prosecution case. But the problem is that what they are putting forward as their case, and bear in mind, as I said at the outset, none of these are witnesses who make any direct accusations against any of the accused. They're just random people who've been picked out to give evidence about specific crimes that have no connection to the accused. And if you listen to remind yourself about the comment made by the ambassador that Mr. Kehoe was talking about earlier on, you can see there are 2 points of view, but certainly the point of view that's been taken by the ICTY in all of the Kosovo cases, and the judgments, if you read them, and by the ambassador and many other people very deeply familiar with Kosovo, is that the crimes that were being committed on the ground had no central control whatsoever. This was just the product of a lawless situation and lots of weapons around and people settling old scores and the outpouring of anger and fear in the context of an arguably genocidal Serbian campaign, but certainly one that depended on crimes against humanity, village by village, as the Kosovo Albanian population were massacred and forced, those who remained, closer and closer to the border, so that the whole place could be ethnically cleansed of its Kosovo Albanian population. That was the context in which these allegations are being made. So, we know what the territory of the arguments at trial are going to be. But for the consequence of that to be that the prosecution just has put anything into the case to the point where there's no regard being given to how long the trial is going to take. At the end of the day, the question, let's take Mr. Thaci, we look at the sentences that were passed down to the Serbian conspirators who themselves had ordered the killing of thousands and thousands and thousands of Kosovo Albanians and the driving of the remainder out of Kosovo so that they could never return, the destroying of their homes and their crops and their animals, and the removal of their documents and the filing of their car number plates and the removal of anything that could establish a connection with the right of return. They were all convicted of crimes against humanity in that period. And the sentences that they were given, varied from sort of 10 years to 15, more or less. So, essentially if you don't step in and act, and, the history, I'm sure you won't challenge me in saying this, is that you have been, generally speaking, given the prosecution enormous latitude so far. And that's why we're in this mess. Right? That's why we're in this state, because you haven't held the prosecution to a tightened up a series of rules. And, you know, when they choose to do what they want to do, just in complete violation of your rules, you never hold them to account. So this is an opportunity to do something about the situation. You, I suggest, cannot properly send a case to the trial chamber, which is due to last 10 years to try. So we have to decide next, what is the procedure for resolving this? Are you going to send a 10-year trial to the trial chamber and let them have to deal with it? Or are you going to do something about it now? Now, I'm happy to put, obviously, I'm not suggesting you would make any decisions on this on the basis of oral submissions, but I don't want to waste a lot of time putting a written submission to you if you're going to turn around and say, this is not my function, right? So I would like you to give an indication today whether you accept it as part of your function to give the prosecution a limit in terms of time, in terms of volume, in terms of number of witnesses, in terms of categories of case, in terms of how they are going to make this case work, or not. Because if you don't accept you have that jurisdiction, let's not waste any time. I'll appeal your ruling and we'll go that way. So I'd like a ruling in principle today, if possible, but not necessarily, about whether you consider yourself to have the jurisdiction to impose limits on the number of witnesses and the number of hours that the prosecution is entitled to claim for the purposes of presenting its trial. Every other tribunal does it. If you don't do it, you will create this case as an absolute car crash. It already is in this situation. It is an extraordinary situation where a prosecution has broken all the rules and broken all its deadlines, lied to the court about what was going to happen in terms of how long the case was going to take pre-trial, deliberately characterizing underestimates in flagrant violation or in flagrant opposition to the known facts and to the experience of other courts, because I'm sure the prosecution think they're better than the prosecution in every other court, but they're not good enough to put a case forward that can sensibly and realistically be tried. Why should Mr. Thaci even go for trial? At the end of the day, if he's going to serve 10 years in prison, he might as well just let you get on with it. Because whether he's convicted or acquitted, he'll get 10 years of his liberty more, because he's already been 2 years in prison. This is a travesty. And so I would invite you to accept your true responsibility to hold this case and put it in some sort of order. And obviously, if you choose not to do that, then it's your responsibility that this situation is completely out of control. So could you please give us an indication of how you would like this dealt with?
Thank you, Mr. Emerson. I will continue the round. Just on your question, I'm not going to make any ruling on this today, especially on the any other business category of a status conference. This is a very serious matter for which there will need to be written rulings, as you just mentioned. There are ways to streamline proceedings. These responsibilities are shared between the pretrial judge and the trial chamber, and everybody will have to take his or her responsibility on this.
Yes,
but this cannot be done at 5:34 in a status conference. But these matters are definitely going to be addressed, and streamlining the procedure and efficient procedure are definitely an important part of our function.
It's not streamlined, it's 10 times larger than
this will be addressed. Thank you, Mr. Emerson. Let me give the floor to Mr. Young, please.
Your Honor, I'm standing for a point of order, please, and it will be brief.
Can you wait for the last defense team? I'll give you the floor and you can make your point once I finish with the other defense teams, please. Thank you. Mr. Young.
Nothing to add.
Thank you, Mr. Young. Ms. Alagendra?
Nothing to add, Your Honor.
Mr. Laws, do you want to add anything?
Nothing from me, thank you, Your Honor.
Thank you, Mr. Laws. Mr. Prosecutor, you have the floor. Thank you for waiting.
It is just a very brief point of order, but I have noted before that we sometimes find ourselves in a situation where the defense teams are making increasingly wild allegations that they know not to be true, but that we then run out of time or are about to run out of time, and therefore we are required to be swift in our responses. I would like there to be a situation that if we have to listen to allegations of these kind that are not on topic, that go on for longer and longer and are completely beside the point, that certainly there will be enough room to respond, because this is no way to run a status conference if there is no limit as to what is done and what is discussed. Thank you.
Thank you, Mr. Prosecutor. I invite the parties to mention in advance when they want to raise specific topics. And in such a topic, which is the efficiency of the proceedings, we have a legal framework. This will be dealt with by written rulings. There are powers of the pretrial judge, notably in the handover document. There are powers of the trial chamber, so that procedure are managed efficiently. Madam Prosecutor, you wanted to add something.
Thank you, Your Honour. Just my colleague responded on the point of order there. I would like to respond in substance. And what I would say is that purely mathematical comparisons of the type presented by the Vassalli defence in their written submissions, and again here today, are of very limited assistance. The defence named some specific cases by way of example. One of those was the Sejnovic case. Even a cursory look at the Sejnovic trial schedule shows that between July 2006 and May 2007, the 10 months during which the prosecution case was being presented, there were 4 entire months when it appears that the court did not sit at all, and other months in which the court sat very few days. For example, in April 2007, it was only 3 days of the entire month. Therefore, for 5 of the 10 months, the court essentially did not sit. So what I would say is a significant degree of care is required in attempting to make any such extrapolations. As for the ICTY generally, different chambers took different approaches to trial management. However, the submission that, generally speaking, no witness at the ICTY could take more than half an hour is not an accurate reflection of ICTY practice. With regard to this case, the scope of evidence and manner of presentation are matters which the trial panel will be empowered to address in due course in accordance with Rules 117 and 118. However, let me be clear, the SPO will be presenting an efficient case. We need to balance factors including the burden of proof and the interests of victims and witnesses in getting to give their account of events to the court. However, we will do so in a manner which is balanced and efficient, as we have done in other cases before this court to date, and it will certainly not be the range of years being put forward by the Vassalli defence. More fundamentally, however, matters are being taken here in the wrong order. The SPO is not in a position to assess ways in which to make the trial more efficient without knowing what it is that the defence agrees to and what it disputes. We provided proposed agreed facts in March 2021, that's almost a year ago, and we understand from the written submissions that defence teams are still considering these, and we're very happy to discuss them. Similarly, should the defence teams choose to file pre-trial briefs, we would want to carefully review them. So we hope that relevant information will be available for the trial panel to make decisions pursuant to Rule 118. Finally, now is not the time or place to debate the merits of the case. That will again be determined at trial before the trial panel. However, contrary to the Vassalli defence submissions, the evidence disclosed and summarised in the prosecution's pre-trial brief is clear about the responsibility of the 4 accused for the crimes charged. It includes contemporaneous statements of intent and knowledge, both written and oral. It includes clear evidence of contribution and participation. And in respect of Mr. Vassalli in particular, there is also evidence of the very central involvement of the intelligence bodies over which he presided in implementing the common criminal purpose. Thank you.
Thank you, Madam Prosecutor. I don't see any requests for the floor, so
Just
Mr.
briefly,
Q,
I just did this one very, very brief comment, which is a comment on the efficiency and their call for agreed facts, etc. Let me remind the prosecution that 106 witnesses are anonymous. 106 viva voce witnesses are anonymous. Again, a rhetorical question. Does the prosecution think that makes it difficult on behalf of the defense to assess agreed facts? What do they think? of course. We have an indictment that is redacted on events and dates and times and people for which we cannot put our arms around, that I can't even discuss with my client. It's an absurd proposition, with all due respect, Judge, to say that we are ready to do this trial, we have thrown these facts and circumstances out, and that the burden is on the defense, given what they presented to us. Thank you.
Thank you, Mr. Kihu. I don't see any requests for the floor, so this concludes today's hearing. I thank the parties and participants for their attendance. As usual, I thank the interpreters, stenographers, audiovisual technician, and security personnel for their assistance. And we will meet on the 24th of March, and I will also inform you if we convene for a hearing on the 22nd of February, once I received the written submissions of all the parties. The hearing is adjourned.
All rise.